All right, let's jump right into this ultimate mental checklist for your Occupiers Liability Act 1957 exams. For this explainer, we are strictly zeroing in on lawful visitors. We are completely ignoring trespassers and the 1984 Act today. If you want to absolutely crush your tort law problem questions, you know you need a highly structured, bulletproof approach. So think of this as your master guide. We're going to break down those complex scenarios, apply the exact right legal tests, and honestly, just secure those top marks you're looking for.
Here is our roadmap for today, starting the claim, the common duty owed, children and skilled visitors, contractors and warnings, and finally, defenses and remedies. You'll definitely want to mirror this exact structure in your exam paragraphs to nail both your knowledge and application points.
Think of this whole explainer as the journey of a claim. It's essentially a precise three-step flowchart that you can rely on when the clock is ticking in that exam hall. First, does the 1957 Act even apply? Second, what specific duty is owed? And third, can the occupier wiggle out of it or reduce their liability using defenses?
Okay, Section 1, starting the claim and establishing that foundation.
You have to lay down the legal foundation before you even think about discussing a duty of care. Otherwise, your whole answer is just going to crumble. The 2008 Poppleton case is a fantastic example of a trap examiners love to set. An amateur climber was bouldering indoors, totally ignored the visible safety rules, jumped from the wall, and severely injured himself. The court said no, absolutely no claim here. Always remember this, the injury literally has to come from the dangerous state of the premises itself, not what the claimant foolishly chose to do while hanging out there.
So your first real hurdle is nailing your definitions early. Who actually is an occupier? Well, it's not always the owner. An occupier just has to pass the control test, meaning they have a sufficient degree of control over the premises. And what exactly are premises? Section 13A gives it a remarkably broad definition. We aren't just talking about land and buildings. It covers fixed and movable structures, vessels, vehicles, lifts, and yes, literally even a ladder. This brings us to the classic case of Wheat versus Lacon, which proves you don't actually need to own the place to be liable. In this case, a paying guest tragically died after taking a fall down an unlit staircase in a pub. The House of Lords stepped in and said both the manager, who rented out the rooms, and the brewery, who actually owned the pub, were occupiers. So keep an eye out for that in your exam facts. Multiple parties can absolutely be occupiers at the same time if they share control.
Next up on your checklist, you've got to identify your claimant as a lawful visitor. Who makes the cut? Invitees, licensees with express or implied permission, people who bought an entrance ticket, or folks with a statutory right to be there, like a police officer. Confirming this status is absolutely crucial because it triggers the 1957 Act under Section 2.1 and officially proves your claimant is not a trespasser.
Moving right along to Section 2, the common duty owed. Step 2 on our journey is establishing exactly what standard of care the occupier actually owes the second that lawful visitor steps onto the property. I really can't stress this enough. Memorize this exact statutory language from Section 2 of 2. Quoting the common duty of care word for word is a massive easy mark earner. And notice the heavy emphasis on the word reasonable. The occupier must take care that the visitor will be reasonably safe for the purpose they were invited for. They aren't expected to wrap the premises in bubble wrap. They are not an insurer guaranteeing absolute perfect safety. Let's look at Rochester Cathedral v. Debell to see how this plays out in the real world. The claimant tripped over this tiny little lump of concrete sticking out from a traffic bollard. The Court of Appeal took one look and said, no liability. Look, tripping and slipping are just a part of the human condition. For an occupier to be liable, there has to be a real, recognizable source of danger, not just your everyday minor blemishes that you'd literally find on any sidewalk.
All right, Section 3, children and skilled visitors.
Let's shift gears and look at how this standard of reasonableness magically changes depending on who the visitor is. Obviously, the law treats a chaotic 5-year-old very differently than a professional electrician. Under Section 2.3a, the law throws a bit of a curveball. The statute explicitly says occupiers must be prepared for children to be less careful than adults. So you have to measure the standard of care subjectively against the child's specific age. What might be perfectly safe for you or me could be a deadly hazard for a toddler. Which brings us to the really tragic 1922 case of Taylor v. Glasgow Corporation, the case that established the concept of allurement. A 7-year-old boy ate poisonous berries from a shrub in a public park and died. The shrub wasn't fenced off, there were 0 warnings.
The council was held liable because they knew about the danger, and those berries acted as an allurement. They were essentially a tempting, concealed trap for a young, curious child. But hey, don't fall into the trap of thinking liability to children is just an automatic slam dunk. Take a look at Bourne Leisure v. Marston. A young child tragically drowned in a holiday park pond while supposedly under the care of his parents. In this instance, the court found the occupier was not liable. Why? Because the danger of a pond is extremely obvious, and parents absolutely still bear the primary responsibility to supervise their own toddlers around glaringly obvious dangers.
Now on the flip side, we have skilled visitors under Section 2(3)(b). In these scenarios, the occupier's duty is actually dialed way down. The law expects that a tradesperson coming onto the property will appreciate and guard against the special, ordinary risks that are just part of their everyday job. The case of Rolls v. Nathan perfectly illustrates how strictly judges apply this rule. 2 chimney sweeps died from inhaling carbon monoxide fumes while cleaning a boiler, and they did this after actively ignoring clear warnings from a heating engineer to leave. The occupiers avoided liability entirely. As competent professionals, those sweeps should have anticipated and guarded against the exact risk that killed them. It was literally part of their trade.
Section 4. Contractors and warnings. So, what if the danger wasn't actually the occupier's fault? What if a visitor gets hurt because of a shoddy repair job by an independent contractor? Well, under Section 2(4)(b), the occupier might try to shift the blame, but they have to tick off 3 specific boxes to do it successfully. First, was it reasonable to hire a contractor in the first place? Second, did they check to make sure the contractor was actually competent and insured? And third, did the occupier take reasonable steps to check the work was properly done afterwards?
Alexander v. Freshwater Properties is the absolute key case here. A visitor suffered a really severe hand injury because a front door at a block of flats was repaired terribly. The court held both the occupier and the independent contractor liable. The massive takeaway for your exams is that just hiring a contractor is not a get-out-of-jail-free card. The occupier stays on the hook if they didn't act reasonably in overseeing or double-checking the work.
Alternatively, an occupier might just try slapping up a warning sign. But Section 2(4)(a) is incredibly strict about this. A warning sign only works as a complete defense if it actually makes the visitor reasonably safe under all the circumstances. What amounts to a sufficient warning? Well, that's a question of fact for the judge to decide based on the specific scenario.
An English Heritage v. Taylor shows exactly why you can't just ignore unusual dangers. A visitor was walking around a castle and fell down a sheer 12-foot drop into a dry moat. There was no warning sign anywhere, and because of the way the landscape rolled, the drop was totally invisible until you were basically over the edge. The occupier was held liable because failing to provide an adequate warning for such an unusual, hidden danger is a direct breach of duty.
Finally, we're at Section 5, Defenses and Remedies.
So, let's say the court definitively finds that the occupier breached their duty. What now? How can the occupier soften the financial blow, and what does the claimant actually walk away with? The occupier can pull out standard tort defenses. They might argue valenti, claiming the visitor fully consented and accepted the risk, which completely wipes out liability. Or they might argue contributory negligence, meaning the visitor was being careless themselves, which just reduces the final payout. And for the successful lawful visitor, the ultimate remedy they're chasing is financial damages in tort to compensate for their injuries or damaged property.
Before we wrap this up, let's do a quick knowledge check to lock this into your active recall. Think back to Section 2(4)(b). Can you name the 3 steps an occupier needs to prove to shift blame to an independent contractor? Remember them? Was it reasonable to hire? Were they competent? And did the occupier check the work? If you can rattle those off, you have totally mastered the mechanics of this act. But I'll leave you with this to ponder. Does the 1957 Act actually strike the perfect balance between protecting everyday people and letting property owners just live their lives? Or is the legal burden on occupiers still way too high? Keep practicing this structure, run through this review guide before your exam, and we'll see you next time.